Welcome to the History Politics Podcast, putting the past to work from UCLA's Luskin Center for History and Policy. We study change in order to make change, linking knowledge of the past to the quest for a better future. Every other week, we examine the most pressing issues of the day through a historical lens, helping us understand what happened then and what that means for us now.
Welcome to today's discussion, Anti-Semitism and the Law in the Second Trump Administration, which is part of the series on the past and futures of higher education in the United States, which is sponsored by the UCLA Luskin Center for History and Policy. My name is David Myers. I'm the director of the Luskin Center. I'm delighted to be joined by our assistant director, Rose Campbell. A few other people will join us in person, which is why I'm at such a distance from the camera to allow them to fill in. But we're delighted to welcome all of you who are online. This is the third conversation of the year in our series as we try to understand the new and fraught terrain on which higher education stands at this crucial and dire moment. The second Trump administration has issued several volleys against universities. The first in the spring, summer of 2025, and then again another round in early 2026, perhaps the end of December 2025 as well. Prior to that time, we should recall, Congress began to scrutinize universities over their degree of commitment to combating anti-Semitism after October 7th, 2023. And along with UCLA, one institution that has drawn a great deal of scrutiny, both from Congress and the administration, is the University of Pennsylvania. You may recall that its former president, Liz Magill, was summoned to Congress in December 2023 with two other university presidents, Claudine Gay and Sally Kornbluth, in the wake of which two of the three ended up submitting their resignations under pressure, including Liz Magill. But that was not the end of the story for Penn. In July 2025, the Equal Employment Opportunity Commission of the federal government opened up an investigation alleging anti-Semitic discrimination at Penn. Government issued a subpoena that included a demand for lists of the names of Jewish faculty, students, and organizations who might have been subjected to discrimination. And what was asked for included personal details such as home addresses and personal emails. The university refused, which prompted a federal judge in January 2025 to ask the university to justify its refusal. And it's in the wake of that request by the district court judge that three faculty members from the University of Pennsylvania joined together to write a piece in the Guardian newspaper titled, "Why the Trump Administration's Demand for a List of Jews at Penn is So Dangerous." To help us understand why, I'm pleased to welcome the three authors of this op-ed to our discussion today, and I'll introduce them very briefly so we can jump right into the conversation. First, Amanda Shanor is Associate Professor of Legal Studies and Business Ethics at the Wharton School at Penn. Sigal Ben-Porath is Presidential Professor of Education at Penn, where she also serves as the faculty director of the SNF Paideia Program for Civil Dialogue. And Serena Mayeri is Arlen N. Adams Professor of Constitutional Law at the Penn Law School and Professor of History by courtesy in the History Department. She's also a core faculty member of the program on gender, sexuality, and women's studies. So welcome, Amanda, Sigal, and Serena. I'm really delighted that you were able to take time out in the midst of a busy workshop devoted to free speech to be with us. We'd like to unpack over the course of our conversation why you think the administration's request for Jewish names was and is so dangerous. But maybe we could just begin at the beginning and ask, what is it that brought you three together? You come from different schools, two of you engage with law, one of you is a scholar of education and philosophy. What is it that brought you together at that particular moment to write the op-ed that you did?
I think Serena and Amanda have been writing in this domain, including together for a while, including a piece that I had the opportunity, and an article that I had the opportunity to read a little bit earlier. And this op-ed, they ended up inviting me to join, I think, because we really come from diverse disciplinary perspectives. I'm a philosopher by training. I'm at the School of Education here. Um, we have differences of identity, of course. I'm from Israel and have experienced some of these last couple of years in a different way based on my personal identity as well as institutional positionality. And I also think we come from different um, uh, values and beliefs in some areas. And so I think it was meaningful for all of us to identify what it was that we really, all three of us, are committed to through our diverse contexts and perspectives and experiences. That's at least my take.
I'll add, these are two of my very favorite people who are incredibly brilliant. And it's a pleasure and an honor to get to work with them and to think through some of what are really hard issues and really pressing ones now. And so I think that that's also part of, really, I think what happened then is all of us were sort of thinking through similar kinds of questions and sort of struggling with how to best respond to attacks on higher ed and academic freedom in a context where a lot of people disagree about a lot of different things. And, one of the things that Serena and I had talked about a lot is like really trying to figure out ways to bring people together in a world of fractures around important things. And I think that was part of the thinking and the motivation too.
I'm curious if it had that effect, if the op-ed, in fact, occasioned some coming together that otherwise hadn't existed. Maybe, Serena, do you have any insight into that?
Well, I don't know if I would give our op-ed credit for that entirely, though I think it was a wonderful experience to work with Sigal and Amanda on it. I think that it might be helpful to give a little bit of additional context to sort of what was going on when the EEOC filed suit against Penn to enforce the subpoena. This was sort of against the backdrop of a charge that had been issued by then EEOC Commissioner Andrea Lucas back in December 2023, shortly after Liz McGill stepped down. And then the investigation was dormant for quite some time. And then some might recall that sort of early in the Trump administration, the government accused Penn of violating Title IX in connection with allowing Leah Thomas to swim on the women's team 3 years earlier, which was something that was at the time, I think, required by then current interpretations of federal law. And shortly after Penn reached an agreement with the Trump administration, I believe is when this demand sort of resurfaced for this list of names and contact information. And I think it's probably worth kind of looking closely at what the subpoena asks for. So the subpoena specifically requests lists of all members of Jewish affiliated organizations at Penn, all members of the Jewish Studies program, everyone who participated in confidential listening sessions and surveys about anti-Semitism, and then the notes from those sessions and surveys, as well as anyone who filed a complaint about anti-Semitism. And the context was that and this was, as David mentioned, this was a demand for not just the names, but also the personal cell phone numbers, email addresses, and home mailing addresses of each of those individuals. And the sort of in this context, Penn turned over hundreds of pages of documents, but refused to turn over these particular pieces of information, the personal contact information and the membership lists of organizations. And I think, I'll just speak for myself, I think after the initial shock of this demand, I think it started to become clear that while, I think Jewish university affiliates and Jews generally, we don't agree on much these days. But this was something that seemed to be somewhat unifying and kind of universally horrifying to people. And so I guess I would say that to some degree, it was the subpoena itself that provided an opportunity to bring people together in this way.
Yeah. So I'm just wondering, what did Penn agree to turn over?
They did turn over, for example, summaries of the listening sessions. They asked the folks who had complained about anti-Semitism for their consent to turn over their personal contact information, and the individuals who consented to that, they did give that information. I'm not remembering. Amanda, do you remember other? It was about 900 plus pages of documents, I think, that they turned over.
That's about all I know, too.
Okay. And one of the unusual features of the effect of the subpoena was that, as you noted, it brought together a fractious and often divided set of Jewish individuals and organizations into a shared effort to resist this demand for Jewish names, including quite mainstream actors who may share the view that anti-Semitism is a very serious presence on Penn's campus. Is that's how it seemed from afar? Is that in fact the case?
So maybe I'll say a word about that. I mean, I actually, David, don't think that we are often or typically very fractured, but I do think that since October 7, we have been more fractured than we've been before. Penn's Jewish community is actually quite robust, as some of you may know, and is not particularly typified by contention. I mean, we surely have people who are more orthodox or more reform or more secular, and we have people with different political and other interests, but we don't tend to be at each other's throat. I mean, there is a lot of space for everyone on this campus, and it has been historically and in and remains, even if in smaller numbers, a fairly relatively Jewish campus. I mean, there is a large Jewish community here, and it's quite a friendly community overall. We have had significant disagreements within this community about the extent to which anti-Semitism has been a concern. People had different views on how to interpret some of the well-known incidents or expressions that we had on campus, including the encampment and other things. And we have had some like open disagreements as to whether the campus responded sufficiently or should have done more. So I think some of our differences, political and experiential, has been surfaced by our responses to things like the encampment, etc. But and so it became more evident to me, for example, that some of my colleagues, just focusing now on Jewish colleagues in particular, based on your question, David, some of my Jewish colleagues as well as some of my students, have had really different experiences and perspectives and expectations than I do. And that was sometimes a source of tension and sometimes just a source of very vibrant discussions, you know. But this subpoena, I have to say, I have not seen much of a, you know, sunlight between any of us. I mean, no one that I've met, and I really hear from a lot of people and try to talk to a lot of people. I don't think I met anyone, Jewish or otherwise, who was not just anything between taken aback or was horrified by this demand. So it brought us together, but in a clearer way. But I don't think it's from a place of a huge fracture, at least by my experience.
Okay, well, that would be, I think, somewhat different than other campuses where there have been very pronounced differences between and amongst members of the Jewish community. But you know, I'm really curious about the provenance, the origin of this effort, since it seems linked to a single person. Then EEOC member Andrea Lucas, who I believe now is the chair of the EEOC. And maybe the personal nature of it helps us understand what's so distinctive about it. UCLA and many other institutions have been subjected to various kinds of assaults. But what seems distinctive about the Penn case is the request for lists of people. I'm just trying to figure out how do you understand that? That's kind of the demand or the ask of Penn. I mean, there have been similar efforts at other institutions as part of a larger assault upon them at Berkeley, and there are reports of that at UCLA. But this seems to be such a singular focus at Penn. I'm just curious about how that works. Like, is this just the idiosyncrasy of a single person? I'm wondering, Amanda and Serena, if you have thoughts on the singularity of that ask of Penn.
So I think it's singular in terms of the ask in ways that are really important for the stakes. But it's also not all that different in some ways. So the administration has asked for the contact information, of everyone at the university, and has been given, I think all employees' information, personal contact information at Cornell. I know at Barnard, they contacted, I think, all the students and faculty with a survey, the first question of which is, are you Jewish or Israeli? And I think that really, really terrified a lot of people. And I'll say, I think that part of maybe why they changed course at Penn is because they've been less successful. I don't know this, but I wonder if they've been less successful in those contexts in terms of identifying people who have had experiences that they want to report with regard to anti-Semitism. So, but I'm not sure. So, but I'll say, I think the ways in which this is a really distinctive ask is really important because of its potentiality to affect all manner of people and all manner of groups, and has really important constitutional bearings. So they're not asking for, this is different from them asking, for example, a list of employees who have X job title and had this experience, or who weren't given the shift they wanted, or et cetera. The way in which they're defining the group of people they want the information for is based upon things that they teach or research, expressive events that they attended or participated in based on the topic of those discussions, and their membership in particular groups based upon the subject matter or interest of the particular group. And they define it very broadly about the sort of like religious, cultural, political, or, national origin related to Judaism, or something very broad. Okay. And those types of categories are types of categories, one, that people don't generally tell their employer, right? It's not like you're going around saying like, oh, and I participate in this type of civic activity, or I'm political in this way, or these are my specific religious beliefs as seen by my membership in this religious group or whatever. But also, those are actually all core First Amendment protected categories. And if the government could demand a list of people who, you know, teach these certain things, go to certain, expressive events, or affiliated with certain types of, associate in certain ways with certain groups, that would be really scary for all manner of groups, right? Not just religious groups, not just Jews, but like, immigrants or people who teach about, the history of race, or you name the type of thing. And not just in the context of this government, whatever you might think of it, but also future governments. And I think that I think for that reason, this particular demand for a list is something that all people should be worried about, regardless of their religion or political ideology.
So it seems to me, but apparently not so to federal judge Gerald Papert, who noted when confronting or addressing Penn's refusal to agree to this subpoena, that the government's demand was ineptly worded, he said, but had an understandable purpose. And since that time, when he asked Penn to justify its refusal, he has since ordered that Penn should, in fact, proceed with handing over the list. What do you think Judge Papert, who I should know was an Obama appointee, if I'm not mistaken, was seeing that we didn't see, that you didn't see, Amanda, or Serena, or Sigal? What could, on constitutional grounds, I'm wondering what, I mean, you've laid out the case for this enormous threat for many groups and individuals, should this precedent be established. What's the counter argument?
As the one person who's not a lawyer here and actually has no idea what the answer is to your question, David, I do want to jump in first. And just to say that the judge has expressly at the big, so I was at the courtroom, of course, all of us were, but I was at the courtroom just listening. And he expressly noted at the start of the of the hearing that history has nothing to do with it. That, so he basically said that the arguments from history and the arguments about threats, potential downstream threats, are completely besides the point. I have to say, as somebody who really, doesn't spend a lot of time in courtrooms at all, if I can help it, this was very jarring to me. What does it mean that history has nothing to do with it? Where will we find anything about lists of Jews? I mean, okay, in the Constitution, which I'm not going to comment on, but the excising of historical context for this request as irrelevant to the debate, for me, was just sort of like as a first step before people made their arguments. For me, was jarring is how I put it, and also disconcerting.
This is very helpful, Sigal, actually, to hear that. I did not know that way. Well, I hope take that up in just a bit, but Serena or Amanda, any insight into why Judge Papert saw it so differently?
So I think that he, both from the opinion and the oral argument, I think that he didn't think that this was invasive of people's privacy in a significant way. And I think that he didn't think that there were significant threats to the people whose information would be put on these sorts of lists. And I think that in significant part, that's because he saw what the EEOC was doing as, a garden variety, the government said, a garden variety type of anti-discrimination investigation. And so I don't think he saw, for example, what I laid out as what's constitutionally distinctive about this type of list, or how it might bear on, people's he didn't see there as being a chill, right? He didn't think that people would actually stop, affiliating with a group, or would actually this would affect their religious practice. He didn't seem to think there was any type of religious sort of stake here. And I think that is, I'll note that, like, following his decision, I know at least one person requested to have their name be taken off of one of the student groups lists out of concern. And I'll say that there is significant amounts of concern that this will actually chill people's willingness to associate with Jewish groups or participate in, Jewish life on campus in very serious ways. And so I think, at least from all the signs from the Jewish community at Penn, those people whose information would be given up feel very differently about the chilling question about whether or not this is something that is of concern.
Not to mention the disregard for the historical backdrop to list making, which has its own ignominious background. Jewish list making in the 20th century has a very, very dark history. The most important episode of which, of course, is the Nazi request to members of Jewish councils to assemble lists of people for the purpose of deportation. There's obviously an American chapter to this sorry tale as well. During the 1950s, the blacklisting and red baiting tactics of anti-communist warriors led to very deleterious effects from the making of the compiling of lists. So it's kind of hard to imagine that someone with any sense of history would argue that, list making need not have deleterious effects. And I think, Amanda, you've laid out a very compelling case why this is different from other requests made, other garden variety requests. It seems to be anything but garden variety in terms of the depth of inquiry being sought. It's not just give us your name and we will get back to you to examine whether you feel you have been subjected to a hostile workplace environment, but that goes well beyond that. So would one expect this, I hope it is the next step, moving to an appellate court and seeking to overturn this request?
Can I just say another word, David, about your historical comment, which obviously is, for me, the core reason to worry about this list. I mean, obviously there are legal reasons, but these are also, the legal case that Amanda and the other legal representatives are laying out is really an effort to protect this group of individuals from exactly the kind of fate that you are describing. And the need for these protections is only just made more urgent because of the historical context that was left outside the courtroom, beyond the cases you are mentioning, David. The City Hall in Amsterdam kept a meticulous list of Jewish families and their residences, and it had a compelling bureaucratic reasons to do that. But that's basically how an entire branch of my family was wiped out, because it was very well known where you can find them. And the City Hall turned over the list. They had not much choice once the occupation of Amsterdam began, but keeping these lists and turning them over has it has a historical context that I think is just misguided to to keep outside of the conversation, even as, of course, we have to think about the constitutional justifications for and tools for these protections. But Amanda, you know probably the most about the appeal plan.
Well, and I guess I'll also add to that I think that the history is something that's very salient to the Jewish community in a way that affects people's willingness to associate. And that is the way in which that becomes like a very important fact for constitutional analysis purposes, right? Because the sort of the First Amendment question is whether or not, there's a risk of chilling of people not engaging in the types of expressive or associational activities that they otherwise would want to, right? And that history is really something that affects what, how comfortable and how safe and how free people feel to, do the sorts of things that they're constitutionally protected to do. But yes, so and then I guess I'll also say, I think, regardless of how salient folks think that history is, I think that in the context of rising anti-Semitism nationally and the ways in which, just the creation of a list that has the names of people and says that they are Jewish, right, as a thing is itself, I think, just genuinely really frightening. But also, like, in the context of data sharing, data security being what it is, that's something, no matter what you think of, the intentions of the government, having that be something that could, go out in the world, particularly given data breaches and the info sharing between, agencies that the government has, touted that it's engaging in, I think it genuinely makes, means that there are genuine, security and other kinds of concerns that people have.
I think one of the things too that I think we tried to underscore is that, as Amanda was saying, whatever you think about the current administration, whatever you think their intentions might be or what they might do with a list, that's actually not significant for constitutional purposes or not required for constitutional purposes to have the kinds of constitutional claims that are being made in this case. And so I can't speculate about what the judge thought, but I guess he seemed to feel that he needed to pass judgment on the current administration in order to find for Penn and the interveners. And I think that was not the case and is part of, I think, what makes this a very strong case. Amanda can say more about, sort of our chances on appeal, but in some sense, both the history and the current administration's intentions are do not necessarily have to be nefarious in order for this to be a constitutional problem.
Mm-hmm.
Right. I realize I didn't answer the concrete question. Yes, we will be appealing. We have to seek, I got distracted. Well, you have to seek a stay. The district court's order said that the university has to give over the list on May 1st. We plan, and I know the university plans to seek a stay of that, because otherwise, if they make a list now, that defeats the whole purpose of the constitutional challenge. And then, the appeal will take several months at least. So we'll be kind of like on a longer time clock. And I'll say I'm cautiously optimistic. I don't want to jinx anything, but like as to both the seeking a stay and as to the ultimate constitutional outcome, because there's a very strong case law in our favor. And I was actually in some ways surprised, because like the First Amendment case law is very clear. There's a history from, like the government demanding lists of members of the NAACP, from, the civil rights period to recent cases about, the state of California asking for a list of major donors from, nonprofit organizations, all, which is to say this is sort of like in the case law is well established for decades. You have strong First Amendment protections and rights, and that is a cross-ideological type of thing. So I'm going to cross my fingers on appeal, even if we have to go all the way to the Supreme Court.
I noticed that we have a couple of questions that have come in on chat, and we'll make our way to questions in just a minute. But I did want to just follow up and ask, I guess, invite some speculation. Well, there are two related questions. One, that which the judge perhaps was not willing to do, but I'm going to invite all of you to do, which is to speculate about intention, speculate about the intent of the government. There's the individual query of Commissioner Lucas, and then there's this larger series of assaults upon institutions of higher education, very often in the name of combating anti-Semitism, often undertaken in the same period of time that administration officials give voice to anti-Semitic sensibilities, which kind of undermine, it would seem, the credibility of the claim that this is an administration singularly devoted to combating anti-Semitism. I mean, how do you understand what EEOC Commissioner Lucas is attempting to do, and more generally, how do you understand, from your various perspectives, what the administration is trying to do in the name of combating anti-Semitism? Do you believe it's possible to see good faith at every turn, or do you, from your various perspectives, cast doubt upon that?
So, I think one of the projects that sort of led us into this, thinking about this area is kind of an attempt to take stock of the administration's various attacks on higher education. And I think the conclusion, and Amanda, you should jump in too, the conclusion that I think we've come to some degree is that, it's not necessarily the case that there is no good faith effort to combat anti-Semitism. Certainly, and it's certainly not the case that anti-Semitism isn't a problem that exists on campuses and across the political spectrum. But I think it's fair to say that the extraordinarily disproportionate penalties that the administration is visiting upon universities and other institutions without following any of the regular processes, associated with what you do when there's a suspected civil rights violation. So, I guess one thing to do is kind of take a step back and, what is a civil rights process normally look like? So normally, the first step that the EEOC would take and the first step that the Department of Education would take if it's a Title VI case would be to, first investigate fully, which usually takes a very long time and involves talking to a lot of different people, and is usually initiated by individual complaints by faculty and or students, depending on the circumstances. In this particular case, there wasn't that. This was a commissioner's charge, which is a very rare occurrence, where one EEOC commissioner decided to file this charge, and didn't really, rely on evidence that wasn't sort of publicly available, statements by Liz McGill and sort of very generalized evidence that didn't say much about whether Penn had, in fact, itself violated the law. And normally you would go through, there's a set of steps that you would go through before, for example, pulling funding. And I'm sure you all at UCLA know much more about this than we do. But at Penn, too, we had an instance of, federal funding being withdrawn without any notice or process. And that's happened to a number of different universities. No attempt to engage in any kind of sort of reconciliation or all of these civil rights statutes require require the government first to try to, come to some kind of consensual agreement with the institution. And indeed, until this administration, I think, experts on Title VI have, which I'm not, have told us that, the ultimate conclusion to these investigations has never before been pulling federal funding. The point is to resolve these issues without doing that, and the pulling of federal funding is kind of the incentive that is sort of held out to cause institutions to come into compliance with the law. So I think all of those things together, suggest that this is not really about combating anti-Semitism, even if anti-Semitism is a real problem and there are people, maybe even within the administration, who care about it. That's not the primary objective here. The other thing I'll say is just, I think it is a very effective strategy to divide people who otherwise would be allied with one another. And I think we see this a lot across a lot of different contexts, and it's part of a larger project of using issues like anti-Semitism, but also DEI and anti-trans policies that people really genuinely disagree about, and using those to further divide communities that would otherwise kind of oppose these kinds of attacks.
Amanda, did you want to jump in?
No, I just want to echo everything that Serena said, and that I think that eventually sort of what we came to was that, no matter what you think about anti-Semitism or how to define it, or whether or not our university or other universities are, responding correctly or sufficiently, that both sort of like in general, the ways in which the administration is making those claims and then leveraging without normal processes really extreme forms of punishment towards universities is not the way, I guess, you should go about these sorts of problems. And that, and I'll say that also about the list of Jews, right? Like, no matter what's happening with anti-Semitism, this isn't the best way to deal with that as a problem. And that Serena and I have a paper, the one that Sigal noted before, talking about the ways in which they're doing this. They're looking at and exploiting really significant divides among people about contested issues, like how to think about, diversity and inclusion, how to think about the participation of trans people, particularly in sports, and anti-Semitism. And in that way, it's sort of like very much dividing communities who might otherwise be concerned about attacks on higher education and, about sort of larger attacks on American democracy.
So my final question really follows on that, and it is, has this strategy of division been a failure? Because in the first instance, various Jewish constituencies have come together in the wake of the attempt to squeeze out of Penn the names of Jews. And this, I wonder, has the subpoena and all that followed from it actually brought faculty and administration to constituencies that very frequently have found themselves at loggerheads together in lockstep. And I wonder, in particular, Amanda, since you have litigated, what the degree of consonance is between your efforts and that of the university. I mean, it would seem that strategy of division has had the exact opposite effect in a number of important domains. Is that an overread?
I don't know if it's overly optimistic, but that's definitely how I feel. So I hope you're right in that read. I think that I can think of nothing that has galvanized the Jewish community to join together more, or the faculty to join together with the Penn administration than the subpoena and opposition to the subpoena. And I think that that's has been a really heartening and great thing in so many different ways. And yes, we talked to I think the interveners represent a different set of interests because it's actually the groups whose information would be given to the government. And we're able to make a number of different types of legal claims that the university can't make. And I think that is important for a lot of reasons. I also think that maybe we have a different view of like the importance of anti-discrimination law and the importance of the EEOC in longer historical kind of context. But as to the question, I think that in a lot of ways we're helping the university and that they recognize that, which is, surprising. At one point during the hearing, Seth Waxman, who was representing the university, said that like this has been the one time that the AAUP has agreed with the administration ever in the history of time. So I don't know if that's true, but it was funny, I thought.
To add to that, I think while this, I don't want to represent this as kind of a singular situation in the sense that it followed shortly after the compact for higher education was presented to 9 universities, including Penn. And that was another instance, I think, where faculty at Penn and lots of other universities and sort of across universities came together to encourage their administrations to reject the compact, and they did. And I think that was a huge step forward and possibly a model for other opportunities to come together. So I don't think you have to ask for a list of Jews, in other words, in order to produce this kind of unity, or at least I hope not.
Great. Okay, we have a number of questions online. I know we have a question here. Ariella is furiously doing something, but would like to ask a question. So the floor is yours, Ariella.
Hey, hi guys. It's great to see you. So I've just been thinking, of course, about the California context. It strikes me. I'm interested in the fact that, I think the issue of lists of names came up first in the California state system before the Penn case, right? Both that Berkeley's list, but also all of Cal State, right? And Cal State actually brought suit. Cal State faculty unions brought suit over the demand for lists, and EOC definitely asked for Jewish names here for University of California. And although only Berkeley actually told faculty to people whose names they'd given, we basically have admissions from the whole system that they gave the name. Like, we know that all the schools gave the names. It's just only Berkeley actually told you if your name was given. And those were on both sides of the aisle, as it were. It was people who had signed pro-Israel kind of October 7th letters and pro-Palestine, broadly speaking. And it didn't, although there were some rallies, there were some, it didn't get the kind of national attention, I think, that the Penn. So partly I'm curious about why if you have ideas about, why is it just because of Penn status or something, why it became such a focal point of national attention, while in California it didn't. And I'm especially thinking that was a subpoena as part of a case. And we have a new case right now here at UCLA based on now Title VII claims about anti-Semitism. And I'd be super surprised if there weren't subpoenas. I mean, that's what they do when they have a case. They want to find more people who have complaints. So I'm just thinking about, strategically how we make it more of an issue, because it did not. And I wondered myself whether that was because people, I think quite wrongly, assumed that the names that were being asked for were the names of people in the only really of sort of people on the pro-Palestine side, but that really wasn't the case. When they asked for names of people who signed letters, they asked for the names of people who signed those first, October 7th letters who were not at all taking pro-Palestine positions. So anyway, I'm curious if you all have thoughts about that as we think about strategy here in California.
Esteemed triumvirate, we turn to you for expert guidance on resisting the efforts of the federal administration to seek lists.
So I'm really interested to hear what Sigal and Serena think. I think I don't have an answer to that. Like, I have no idea. I think that I do think the fact that the Penn administration opposed was really important. I think some of the kind of actual people and their experiences was really important. So I'll say our general counsel is a Jewish woman who is, I don't know, older than me, and I think has a historical memory that I think that it was significant in this context. Is I think that like she saw this to be dangerous, even though, she's like a normal general counsel and doing things I don't always agree with. So, do you know what I'm saying? And so I think that mattered. I also think, we were lucky or something about some of the early press. And I think in part that may be, but I don't know, because of, what the media outlets are and the people who read and watch those outlets. Like, I think that, but I'm really interested to hear what Serena and Sigal think. One other thing, I also think the timing mattered, because I think before the compact, like, universities were just rolling over left and right. And I think after it became clear that you make a deal with the Trump administration, they don't leave you alone. I think that was significant learning, including on behalf of like our leadership. And so I think those things in combination, I think, helped here.
I would just, by way of advice, if any, I would say that you need a big tent with a small cause. You need not to try to have some kind of an omnibus that will resolve all of your fractures and disagreements. You need to basically say, the way that earlier petition did and some of these efforts did, do you want a list of Jews and their home addresses? Do you want to be on that list? Right? It's a very narrow and easily identified with cause, right? And you need to try and say, we can keep our differences for tomorrow. Today, we need to get our freaking names off the list, right? It's so visceral, and I think it is some kind of a shared historical memory and self-understanding. If we agree on one thing, is that we don't want the list, right? So we can do something with this very minimal but quite core, this, like agreement among us. And I think the more, invite everyone. They don't have to be Jewish. They don't have to be pro-Palestine or pro-Israel or wherever you stand. They don't need to be, AAUP or with or against the administration. Help me not be on the list and I'll help you not be on the list. You know what I mean? Like, it's a very so it's a small cause with a big tent. And I think this is the way, this would be my advice. Try to not build on that. Try to do just that. Really sort of like to a broad audience. And if that works, with God's help, then you can then you can maybe build on this agreement to get further on other causes, but separate them.
I don't have much to add to my colleagues' brilliant thoughts on this, but I will say, like, from the outside, I've been enormously impressed and heartened by how you all at UCLA have come together with letters and petitions. And I mean, we I don't I don't I don't want to speak for, but I don't know that Penn could have done that. And of course, we now can't because that would create a list of Jews. But but I guess I would put it sort of back at you, as I would be asking you the same question of how have you done that, which I think is a really enormous accomplishment.
So amazing, astounding, like, wow.
Well, it seems that way.
Yeah.
And sometimes it doesn't. But I mean, I'd say in the case of Penn, the wide sweep of the inquiry has allowed unlikely partners to come together, and that really is an opportunity. That it's the Hillel effect, right? You have JDP, and you have strong pro-Israel groups, presumably all being subjected to the same treatment, and that's an opportunity, and one that we should get better at seizing upon. To pick up on Sigal, but I think we have a question online.
So we have a comment and a question. So do you want me to read the comment or invite someone to?
You can just go ahead.
Okay, so I'll go ahead. The first comment says that this is from Devorah Yanel, and it says, in fact, the impact of the wartime list keeping of Jews maintained by Dutch local governments echoed for many decades. When in the mid-1990s, Soviet immigrant friends asked their synagogue for a list of members so they could personally invite everyone to their son's bar mitzvah, they were told that no such list was available because of their use during the war. That's our comment from Devorah Yanel. And then we have a question. Okay.
And then we have one more question in the room after that. Yeah.
So our next question is from Dina Davis, who asks, why was it not acceptable to the judge what Penn had offered to notify the campus that anyone who felt they had been affected by anti-Semitism could contact the EEOC?
Amanda, that may be yours.
That's a great question that you ask. There is not an answer in the opinion. There's a footnote that says, the university, the university's offer is unacceptable or insufficient or something like that, full stop. And so there's not really, I think that the idea is, given the oral argument, that there was concern about the university intermediating in the conversation or being able to read the emails of people if it's over Penn emails as opposed to personal emails. But I think that there's no explanation legally why that isn't still a narrower and less burdensome alternative, especially because you could do a lot of things, and them sending it out, and you can reply. If you reply, it goes directly to the EUC, or it says, don't use this email, use your personal email, or use your cell phone or something. There's a lot of ways that it could be done that I think wouldn't have that problem. There's no discussion of that. The district court, I think, just didn't want to engage with what the other alternatives might be.
And I think one thing that was mentioned in the hearing, in the oral argument, was that that's not how things go. And that, again, as a non-expert, that was confusing to me, because clearly, for example, the way that this subpoena and this complaint originated was also not the way things typically go, but that was acceptable to the court, whereas Penn's suggestion that they would circulate an email to all members of the community and would be like, the EOC is investigating us for anti-Semitism. If you want to contact them, here is an email and a phone number, right? And the EEOC representative basically said the employer, or, the institution that's being investigated, cannot mediate the collection of information, which really, and that's basically I think, is what is reflected in the footnote that Amanda was mentioning. I'm just saying that as somebody who is literate, again, in words, but not necessarily in the law. I think that the justification for not doing that was not, like for rejecting this suggestion, which I think is a pretty good suggestion, or you can give a list of all Penn employees, everyone, and then you can email, the EEOC can email everyone and say, have you experienced or witnessed anti-Semitism? Because I just want to say, anti-Semitism, as you may know, is not the problem of Jews, right? Is everyone's problem. And if somebody is being anti-Semitic, you can see that even if you're not a Jew, right? And maybe this person who's being anti-Semitic also is not a Jew, right? So you can send the email to everyone and you will just get more information, right? But that was not acceptable. And this is the um, boundary of my literacy. I didn't get why.
Just along similar lines to that, I think one of the other, I'll just say, inconsistencies is that, us theoretically, if you're wanting to fight anti-Semitism, you probably don't want to discourage people from attending listening sessions about anti-Semitism or responding to surveys about anti-Semitism, which once you say you do that and your name is going to be on a list that goes to the government and that your employer collects for that matter, especially if you think that Penn is engaging itself in anti-Semitism or is condoning anti-Semitism, it just doesn't make a whole lot of sense to do what the EEOC is doing here.
It seems the only outlier is that Judge Papper didn't understand that, but maybe that can be corrected. A final question.
Final question. First of all, thank you very much. I have two points. My question was shifting because of how the conversations went, right? But I want to know exactly what is asked and how this list could be undermined, as you suggested in the final comments, right? So, because how I picked it up from the press and so on was that really they wanted a list of Jewish faculty staff and so on. And that the response was, we don't have such lists because we don't have that information, right? But from what I gathered here is that actually they wanted to have the list of these groups and of people signing this and that. And maybe it was a combination of what they asked. As far as I know, at UCLA, they have not asked for a list in their accusation of anti-Semitism, have they? Of lists of
I don't think that's for
Not in this most recent suit, but there are two things. One, they asked Cal State, the entire Cal State system, for lists, and two, Berkeley admitted over the summer that they had given lists to the EEOC based on EEOC investigations of anti-Semitism. And it came out first. I mean, UC San Diego this only came out because 160 people got messages from UC Berkeley saying your name was given to the government. No other UC did that. But they basically, I was in a meeting where Darnell Hunt essentially admitted that they gave them, and UC San Diego, they publicly admitted that they gave them. I don't think there's any reason to think that any UC did not give lists. But those lists were asked for based on letters that people had signed.
Yeah, but that's a little different, right?
They were not lists of Jews. They were principally, I think, lists of pro-Palestine folks. And
they included all of the people who signed. There were far more Jewish people who signed. First of all, some of those letters were Jewish letters, and there were far more signatures that were about October 7th from a pro-Israel standpoint. The people at Berkeley the only one who came forward publicly was Judith Butler. So we think that they're the pro-Palestine, but I think that is an error to think that. I actually don't think that's the names that were. I think they
office for civil rights.
It's a difference of having a list of people who are against Palestine, Israel, whatever, but a list of Jews. And in fact, I think there's a difference.
Right.
But anyway, so I would like to be very clear about what kinds of lists are requested or not. But the other thing, so the first time when I came to this country was appalled about lists is, and I just put this in the room and I don't know if it changes anything, was when there was the suggestion that there should be a list of undocumented, what have become the dreamers. And I thought, who wants to put their name on that list, right? And then people did sign up for it, 2 million or whatever. I was really shocked that people came out. And so there it was some kind of it was coming out of the dark, saying, yes, I am one of them. This was this moment, right? That they felt that this was empowering. This was really very confusing to me. And I don't know what happened to those lists. And if there's a backfiring now of this existence of these lists of undocumented people who came here as children. But just to say, this sort of list, it's not just for the Jews. I mean, yeah, as I said, at the time, I was appalled. I don't have Jewish background, so, and still I was appalled about this list. It's supposedly for a good case, but clearly with the potential of being able to be used different. So I don't know if this widens this discussion about lists or if this adds something or not something, but that's in my mind. And how these lists can be actually undermined also by just everyone puts themselves on the list. It doesn't matter. I can say I'm Jewish if I'm not, if that helps the cause.
I'm just going to read from the LA Times in October 13th, 2025. This is 6 months ago. At Cal State, a faculty union filed suit Friday in state court after learning the personal phone numbers and email addresses of 2,600 Los Angeles campus employees were turned over to the Equal Employment Opportunity Commission, which is investigating employee complaints of campus anti-Semitism. In addition, the EOC is contacting Jewish faculty across the 22 campus system, prompting campus demonstrations against cooperating with Trump. These are all campus anti-Semitism investigations that are leading to the collection of names and addresses. And I don't think it is primarily people like Judith Butler because they're looking for plaintiffs. So they're actually more interested in the people.
The Berkeley case may be a bit different if you read up on that. It seems it may be a bit different, but there may be differences of the focus. Let's maybe just conclude with Soraya's kind of general question about lists, and it really affords you an opportunity to offer your final thoughts on what has been a really stimulating conversation. So who would like to go first?
Well, I just want to just underscore what was just said. I think largely of course, we're as Jewish faculty members appalled by this particular demand, but really the larger significance of it is even more horrifying. And I think, I just want to underscore that it's not just about lists of Jews, but it's about lists of any group, as Amanda was saying earlier, lists of Muslims or immigrants or trans people or people who study immigration or race or gender or anything else that this administration or any other administration thinks is objectionable. And I also want to say we've been focused on universities appropriately for the topic of this seminar, but the EEOC, covers all employers or almost all employers in the United States. So it's not just about universities either. This would mean that the EEOC could say to any employer, we think you're discriminating against X group, give us a list of those people. It has just really incredibly disturbing ramifications. So I think this, it's really important to think about it, both as the horrifying history of lists of Jews in particular, and lists of other vulnerable groups, but also this kind of larger context and the precedent that it could set.
I'll maybe add one more word, and I really appreciate your comments here and the context, Serena, which I completely agree with. And I would say that I'm grateful that Penn as an institution has understood that they have to rise to this moment, and they have to make sure that they protect the privacy, the associational rights, and the safety of their employees and, their faculty and their students. And that for me is not to be taken for granted. I mean, a lot of institutions have failed to do that, even in the face of clearly unconstitutional demands. And so I just want to say that I'm grateful for that, and I would hope that it's contagious.
Amanda, final word?
I completely agree. I think that I take a couple things from this experience. I think that, like Serena said, I think it's really clear to me, given the particular things that they're asking, that this is something that everybody should really care about, because it goes to the very core of like having any type of civil society capacity, right? And any type of rights to express, to teach, to research, to publish, to have discussions on any topic, right? Is to associate religiously, politically, culturally, is like the ability of a government to have this type of power is not something that anybody should want to have. And I really think goes to the very core of what sort of like democratic freedoms are. And I think that's part of why, and I guess this is the second thing, I have been incredibly heartened by the response here, right? And that's both the universities, right? Like it has been, I don't know how often I feel just like proud to be a Penn, but I feel really proud. And I feel really proud of my colleagues and students and everybody who has sort of like come together and said, how this is really important, and, to be brave and to stand up. And I guess I hope that's contagious too.
David, on the judge is actually appointed by Obama. I just saw it.
Yeah.
Okay.
On that wonderfully and uncharacteristic, optimistic note, hopeful note, I'd really like to thank from the depth of my heart, Amanda, Sigal, and Serena for being with us, for the extraordinary work you've done, and for really sharing with us in detail how you went about both writing your op-ed and engaging in a noble act of resistance. And we share your hope that we learn from your example and continue to uphold the values of higher education that have made the American university system such a source of pride. So thank you so much for being with us.
Really grateful for you all too. Thanks so much for having us.
Thank you for having us.
Thank you.
Thank you for listening to the History Politics podcast, Putting the Past to Work, from UCLA's Luskin Center for History and Policy. You can learn more about our work or share your thoughts with us at our website, luskincenter.history.ucla.edu. Our show is produced by David Myers and Rosalind Campbell, with original music by Daniel Reichman. Special thanks to the UCLA History Department for its support, and thanks to you for listening.